your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is a Melbourne City solicitor and lawyer. Good morning, David.
Good morning, Raph.
You don't have homework, but I want to hear your take. We spoke about it yesterday. VCAT made a ruling. It's interpreted by many as a whole lot of minor issues for body corporates having to go to a special resolution. Is that the way you see it?
Yep.
So what's that mean? Sounds cumbersome.
Well, a special resolution is a resolution passed by 75% of those people entitled to vote. That's not 75% of people who come to a meeting, 75% of those people entitled to vote. And particularly in the larger owners' corporations, the level of apathy is extraordinary. Now, the case turns upon some wording in the Owners Corporation Act about civil jurisdiction. What's the civil jurisdiction of a magistrate's court? And what the case says is that in terms of this particular question, civil jurisdiction means the recovery of an amount of money of not more than $100,000. So what's the civil jurisdictional limit of the magistrate's court is one could argue that it's for the doing of acts or restrain you from doing of acts. And what the case says, and it's money. So anything other than money. So if you and I live in an owners corporation and the owners corporation wants to sue you for leaving your rubbish in the lift, that requires a special resolution on the basis of this interpretation, which I think is right. But it's
you're
something
saying the interpretation is correct?
I agree with the interpretation, yes. And that's because if you've put this, the Magistrates Court Act says jurisdictional limit means $100,000.
Yeah, I understand.
And the words used in Section 18 of the Owners Corporation Act is civil jurisdiction limit. Well, and what the case says is, well, in order to make logical sense of that, it has to be money. It can't be.
So I understand.
So if I want an injunction to make you behave in a particular way because you're breaking the model rules, yes, I need to get 75% of.
So this is where it gets crazy. I understand the legal reasoning, but it means that every minor, or not every, tons of the minor matters.
Owners corporations can't do anything about is really what it comes down to.
That seems unworkable.
Yeah, I understand. So it requires a change.
Right.
It requires a change in the legislation in order to, it may well be that a member at VCAT comes up with a different decision we then have this issue about whether precedent applies or doesn't. The easiest way to fix it with certainty from now would be to redefine or rework Section 18 of the Owners Corporation.
So do you agree with the verdict from I think it was the Owners Strata Alliance? They say it's anarchy for owners corporates.
Okay. When your producer said anarchy, I'm thinking a place near Geelong. No, not that. Okay.
Is it anarchy?
Yeah. Yes, because now what you've done is you've taken an extraordinary amount of power away from the Owners Corporation, and it's it's the fourth level of government that nobody pays any attention to.
Fourth level of government?
Well, it is it not? It's kind of like it's a council for your building.
It is.
Yes.
Fourth level of government. You've never used that phrase before.
You've never asked me.
That's gold.
Yeah.
Okay, there you go. If you live with others, that may discomfort you somewhat. Let's get to some questions. Lee has a query calling from Armidale. Lee, what's your question?
Hello, Raph and David. I have a question about the statute of limitations on art fraud.
Describe for me what you mean by art fraud. You found a book published 15 years ago that had something in it that you thought was yours?
No, I am the fraudster.
Oh, okay. Do you want to confess to us, do you, Lee?
Well, I sort of am now, but I want to know when I can do it without compromise. I was previously employed to fake art. I was paid by someone else to do it. That was my job, 40 hours a week.
I think that's now called homage art, isn't it, Lee?
Yeah, Yes, it is.
Are you wondering when you can fess up to it publicly and not be prosecuted?
Correct.
The statute of limitations that we talk about is normally in the civil context.
Yes.
Actions in the magistrate's court need to be brought within 12 months of the offence, but depending upon the value of the item you're accused of copying, there wouldn't be a statute of limitations. So if you were to, copy a Renoir and sell it as such.
If only.
I don't play down your talent, Lee. It's not good for you, right?
Okay.
So there is no limitation. There is no limitation.
There is no limitation.
On the crime, no.
Confess to it.
No.
Okay.
So you can
Thank
take it to your death, Lee.
Yeah. Do you do a good Charles Blackman, Lee, or some other Australian, John Olsen?
No, I was very good at Brett Whiteley.
Who?
Brett Whiteley.
Oh gosh. Okay.
Okay.
Nothing big. Nothing big.
Big.
So we're talking to somebody not called Lee who's not from Armidale. We're fine.
100%.
Yep.
Correct.
Okay, Lee.
Thank you, Lee.
Don't say anything else, and don't only confine it to a deathbed confession. Keep it in house. There you
Only
go.
if your estate has no value. We'd
Only
want a
if your estate has no
compensation
value.
claim. Yep.
Because they can come after the estate.
Well, absolutely.
Wow. Lee, you still there?
Yes, I am. As I was mentioning, that there's a whole gallery in the V&A, which I found many, many decades ago when I was wandering through, called the Forges Gallery.
Yes, in
and it's
London.
all the things that they've discovered after they bought it were actually turned out to be fakes.
Sure.
And some of them were very, very good. And they only found out because someone had confessed on their deathbed. Some of the notes said.
So, Lee, I'm going to ask you a question. I feel like I should advise you not to answer, but I'm going to ask it anyway. Okay, you can choose how you answer. Because there's some really famous, controversial Brett Whiteley pictures that are copies that have previously fooled collectors. Are any of those got anything to do with you?
I don't know. I try and keep away from that. I don't attend those auctions, for instance, or those sales, and I don't point to it with my friends and say, look at what I did there.
Good move, Lee.
No,
Good move.
it was,
Look, Lee, I'll leave it there. I don't want to lead you further down a particular garden path, although I'm tempted to grab your details and see if we can explore it further. I'll put you on hold. If you want to hand over your real details to the producers, we'll see what we can find out. It's 13 minutes past 10. David Whiting is taking questions. We don't get many questions like that. Andrew is calling from Greensborough. What's your query about, Andrew?
Yeah. Hi, guys. So it appears that our neighbour has poisoned plants in our garden by basically spraying herbicide over the fence. We're just in the process of getting that confirmed through an expert report. And we believe that it may have happened because basically they're blocking his view. He's got a window that looks right out over our backyard and doesn't give us any privacy, so we planted some screening vegetation. So if we can get that sort of confirmed by an arborist expert, what's our legal position?
Well, what you're going to be able to get confirmed is that there has been a herbicide sprayed on your trees or plants, not that it was your neighbour that did it. If you're getting the arborist to look at it, you might see if there is surface poison at different concentrations on different sides of the tree. All right, because clearly if the neighbour's reaching over the fence and spraying, it's more likely to be on one side of the plants than the others. If it's that kind of herbicide,
Is it illegal?
Oh, absolutely, it's trespass on goods. It's and yes, you'd be able to obtain an injunction. And let's say you had a really nice tree in your backyard, and I came along and poisoned it. The compensation for destroyed trees is mammoth.
Oh.
So you might have a claim for compensation and reinstatement, Andrew. But your argument is going to be you're going to need to persuade a magistrate that it was your neighbour, not someone from your neighbour's house, but the person who did it. Right?
And is that on the balance
on
of
the balance of
probabilities?
probabilities, because you're not alleging a criminal act. You're just it's a damage to your civil rights.
Yeah.
Does that make sense, Andrew?
Yes, it does. Thank you.
Okay, no worries. Good luck. What sort of plants, by the way? Is it trees or something else they've damaged?
It's a range of native shrubs and trees, and also some fish kill, which happened at the same time.
Okay. Good luck gathering the evidence, Andrew. Robin is calling from North Fitzroy. Robin, what's your question about?
Yeah, hi, David and Raf. Thanks for taking my call. I'm calling to see if you might be able to help us understand the legal situation my nephew is now in. He's a 21-year-old landscaper. When he was an apprentice, as a 19 or 20-year-old, he was involved in a minor car accident driving a work vehicle, which we believe was not insured. But what we do know is that his boss at the time prevailed upon him to wear the consequences. And now he's entered into an arrangement with an insurance company and his wages are being garnished, I guess, each week. We're finding out about it after the fact. Had the family known about it when it happened, we may have been able to help, but he took the responsibility for it at the time without sharing it, and we're now wondering what steps we might be able to help him take to get himself out of this situation.
Robin, you need to understand that the person who's responsible for the accident has a responsibility, right? So your 21-year-old nephew, or then 19, is liable for the consequences of what he's done. Now, but I'm not sure about, so I'm going to take some homework on this. I do know that it would be open to the owner of the other vehicle to commence or maintain proceedings against your nephew's employer on the basis of a concept called vicarious liability, where someone is responsible for the acts or omissions of another. So the employer would be responsible to the owner of the vehicle for the damage caused. What I need to think about is whether your nephew has a right of indemnity from the employer, whether it requires an action by the owner of the other vehicle or by your nephew to have a go at the employer. I'm inclined to think that it doesn't matter and they both work, but right. I would. Can I take that as homework?
Sure. Look, thank you for that. I thought that had the car been insured, then it would have been the employer's insurance that would have taken or worn the consequences of the accident, even though it was my nephew's fault.
Yeah, quite possibly. In fact, it would have been, but it's you need to understand that the insurer sits technically behind you, not in front of you.
Yep.
So I think it's probably the employer's responsibility. The question is now, having entered into an arrangement, it's likely that your son can commence proceedings for an indemnity if he needs to, but can I tell you next week?
And how much is it costing him, Robin?
I don't know.
Like $10 a week or 100 or?
No, look, it's a couple of hundred.
A week?
Yep.
It's significant.
Yes. Right. Wow,
yep.
okay.
Yep.
Okay, look,
Thanks,
we'll take that one as homework, Robin. Thank you. By the way, someone says you're potentially wrong. Owners corporations are not the fourth level of government because that's the AFL.
Okay.
So I think that's a text from Scott. I think Scott might have a point that the AFL comes in as another level of government before owners corporations.
It's certainly there. Yep.
We'll get back to more of your queries and questions for David Whiting in just a moment. Raf Epstein with you every Tuesday with David Whiting. He is here every Tuesday. He is here even next Tuesday on Cup Day, answering your legal questions. You're not going to Flemington?
No, not going to Flemington.
Have you been to the Cup?
Oh, yeah, lots of times.
Lots of times. Not going this week? This year?
No.
Okay. Callan is calling from Croydon. What's your question about, Callan?
Good morning, David and Raf.
Morning.
Fire away, Callum.
David, I was just wondering, I've always had an insurance policy, health insurance, and I've always asked for one that got me out of the Medicare levy for my wages. And I've just realised that over the years, they've always sold me the lowest one, and I've been paying a Medicare levy for years. And I didn't realise there were higher levies. I could have paid for a couple of $100. It would have saved me up to $10,000 over the years.
Yes.
I've always asked them for the one that got me out of. They've said, why do you have the policy? And I've said, oh, my reason is for the Medicare levy, so I don't have to pay it on higher wages.
Okay, Callum, let's take this a step at a time, all right?
Yes.
It is against the law in Australia to offer medical insurance.
Oh,
you can take what you're taking with your insurance is hospital cover and ancillaries. Now, a long time ago, I can pick there's an accent, so you haven't been here forever, is that you used to be able to get medical and hospital insurance. So you can't get insurance to cover your visit to the doctor. You can get insurance if you are admitted to a hospital, but not for visiting your GP and for lots of attendances at that level. So that's what the Medicare levy is all about. It's to fund the government's contribution to your medical expenses, not your hospital expenses. Right? So you're going to have to keep paying your Medicare anyway.
But Kellen, are you wondering whether or not you can take a legal action against the insurers because it would have been cheaper to pay the high income Medicare levy? Is that what you're wondering?
Yes, for a couple of $100, it would have been over $100,000, whereas what I've paid is up to $93,000 or something.
Understand. But I think he wants to know, David, if he can. He's essentially saying the health insurers made some sort of misrepresentation to him. It would have been cheaper if he'd paid the high income levy for Medicare. Has he got any action against the insurers?
He's got to prove that he was misled. And I had a conversation with someone at your call centre 4 years ago, and I'm sorry, that sounds a bit hard for me.
Right.
I think we're talking about the contribution to your expenses that you're paying, are you, Callum?
Yes, it's sometimes up to $4,000 extra.
Yeah, so really it's a question of it's up to you to choose the policy that you want, and the problem is we live life with call centres, not across table and discussions with people. I think you've got incredible difficulties of proving that you didn't get a benefit by that you specifically told them, I want the most expensive policy, and you gave me the cheapest.
Oh, okay.
Yeah.
Oh, just going to put it up to Lady Luck, I think.
Yeah, I think so, Callum. You're not alone in feeling frustrated by that experience, but I don't think you've got any legal recourse. Sylvia is calling from Northcote. What's your query about, Sylvia?
My question relates to getting an exemption for land tax for holding two principal residences for more than 6 months. Specifically, I need to know whether to move before or after 31 December this year to be eligible to apply for an exemption. So I bought my new residence on the 27th of March at auction and settled 1 July. And I sold my old residence on the 14th of October to be settled on the 11th of February. I've got conflicting answers from the State Revenue Office when I've rung them. So I'm asking you.
Okay. Sylvia, it's another homework one. That Raf, you were allowed to own two properties for a period of 6 months without paying and get the benefit of the primary principal residence for the 6 months for while you own two properties, right? But it can't be longer than 6 months. Sylvia, what you would do is, if I was you, I'll find out whether or not the period can be extended, but I don't think it can. We got a call a few months ago about someone who was doing an extensive renovation.
That's right.
And they were living in the old house while they were doing the new one. Sylvia, I would be, if you can't get out of it, live in on the 31st of December, live in the one which has the greatest land tax liability and therefore reduce your land tax bill.
Yeah. From what I read on the website, though, you can apply for an exemption in my situation. It's just a matter of when the exemption applies,
Homework.
When you move, and it makes a difference.
It's a question of where you're living, but Sylvia, I'll take the question on notice. I'll give you the answer next week.
Okay.
Thank you.
Good luck, Sylvia. So just a reminder, when David takes homework, he not only burns the midnight oil doing it, but he then delivers the spectacular results straight after the 10 o'clock news on Tuesday. David looked at me in dismay when I said spectacular. Mind you, by the way, we've got another contender for the fourth tier of government, Transurban. according to Mark in research. And I think Mark,
I think Services Victoria is probably up there.
oh, maybe.
Fines Victoria.
Fines Victoria. Yeah, but everyone not everyone. More people pay Transurban than pay fines to Fines Victoria. So I'm putting in, I'm backing Mark's bid for Transurban as the fourth layer.
Apologies for starting the argument.
That's okay. John's in South Melbourne. We've got Sylvia with her homework. John is in South Melbourne though. John, what's your question?
Thanks very much. I've had water damage from a leak upstairs. I'm in an apartment block, and I have provided the owner 2 quotes using the body corporate company's approved providers. Now, the owner's come back to me and says that the 2 quotes are too expensive and they want to use their own trades. And they've recently put the property on the market for sale, and obviously I want this resolved prior to the sale of the property. So I'm just wondering what options I might have.
If the problem is coming from upstairs, it's upstairs' problem to fix it. It's not up to you. I understand what you've done. I think it's great. You've got 2 quotes from people that the owners' corporation will allow in the building, but it's not your choice. It's their choice to stop. How they stop the leakage is up to them, not up to you. So I probably do 3 or 4 things. I would probably tell the owners' corporation that the neighbour's proposing to use a tradesman who may or may not be approved to undertake work on their unit would be number 1. When the property goes on the market, I would be advising the estate agent that there's a leakage, and if there was any leak damage after the date of settlement, it would be the responsibility of the purchaser. And if there's an auction, then I would probably hand out some paperwork at the auction to say, I live downstairs, and if you buy the property today and there was a water leak tomorrow, you have to pay for it.
You can do that. You can hand out that thing.
It's not, one could argue that that's not...
neighbourly.
Well, no, it's clearly not neighbour, but we're talking about a near-to-be ex-neighbour, aren't we?
Yeah, we
right?
are.
So that would be, you're not disrupting the auction, you're just wanting to make sure that everybody's fully informed. There's a leak, you're not sure if it's fixed, and the way the contract, the land contract is drawn in Victoria, notices or issues arising out of the date after the date of sale are the problem of the purchaser. It's not the possession date, it's the contract date.
There you go. Is that helpful, John?
Look, it does, but I suppose they've advised or provided a funder's report saying that what they've done, but it's obviously the water damage, obviously the ceiling and tiles falling off.
Okay, that's a responsibility of the person who's there now. All right, now and if we're talking about quotes, so let's split it in 2. The guy upstairs says, or the person upstairs says, the problem solved. We're now talking about cleaning up your ceiling and your unit. Right? It's a question then of what's the proper cost of fixing the problem. Now, you need to be satisfied that that person's nominated repairer is able to do the job properly.
Right.
Right, so you may come along and say, well, I'll take the money and I'll spend it on my nominated person and kick in the extra money to be absolutely certain it's done to a standard I find acceptable.
Right.
Is it still the responsibility of the new purchaser or not?
To meet the cost. So if you think about it from a drain point of view, the person upstairs has to stop the water flowing and then has an obligation to make good the damage of the water flow. Right? So has control of the leak and has the obligation to compensate for the damage.
Okay.
Right. I suppose the rationale for going through the providers through the body corporate is that there's some recourse if there's any ongoing issues, whereas
if you are paying the contractor, and so if there's an ongoing leak, it's still an upstairs problem. It's not your problem.
Yeah.
Right? You're rolling them into one problem. They're not. They're 2 problems.
2 separate
One is the
things.
leak. One is the repair.
Okay.
Thanks.
Good luck, John. Good luck. So you got a bit of homework there?
I do.
Okay. Enjoy.
Good thing I got a day off, sort of.
Sort of. David Whiting, he'll be back next Tuesday with his homework, answering your questions next Tuesday as well.